Hi, good afternoon, everyone. Thank you for joining us today for our second Wednesday coffee break session with Foster Swift. My name is Robert Hammer. I'm going to be the host for today's session. We actually have an interesting and exciting panel here. For the first time, we are featuring two guest speakers. We have first Ray Littleton the second, who is an equity partner at Foster Swift, Collins and Smith. He is also the chair of our diversity committee, and practice consists of work with general and commercial litigation, and healthcare law. Also joining us today, we have Cliff Hammond, who is an equity partner at Foster Swift, a member of the Diversity Committee, and is practices in employment and labor and general litigation matters. I do a lot of work with Cliff on my own corporate practice, so he has to deal with me on a fairly regular basis. And today we have a really exciting topic and something that kind of struck me out of the blue when I was learning about it is the emerging law in the area of employment discrimination and corporate DEI initiatives, which is obviously a hot topic, something that is very near and dear to us at Foster Swift. In fact, I believe we're one of the few Mansfield certified law firms based on our diversity and inclusion metrics and certifications and things like that. So, but again, when I heard about some of the topics we're talking about today, it definitely struck me as why I did not expect that we were going this route. So, to start off the session, Ray, can you kind of tell me a little bit about the new decisions that's come out of the 11th Circuit and what its impact is on areas of employment discrimination and DEI initiatives?
Thanks, Rob, and thanks to everybody who's here in attendance. Today's topic definitely is one that kind of personally hits home for me because me being here, the diversity chair for our firm, and we were very proud to be able to become Mansfield certified, and so like I'm sure many other organizations, we definitely have a push here for diversity within our firm. And so today's case that we're going to talk about is one of importance because this is one of the first cases that is reaching now the private sector. I think everybody probably on this panel has already been made aware of the Supreme Court's decision in the affirmative action case involving Harvard, and where the Supreme Court overturned race-based admissions, and I think the case was called Students for Fair Admission against Harvard, and the general theory was, well, this case is just going to be limited to the public sector, but just recently, I think the case, the date was October 3rd, 2023, so that's just last month. The 11th Circuit Court of Appeals came out with a decision in a case called American Alliance for Equal Rights versus Fearless Fund Management, LLC. And what ended up happening is the 11th Circuit enjoined a diversity program that the Fearless Fund had, in which they had a grant that was given out to Black, female, minority venture capitalist startups. And so this was kind of a groundbreaking decision. And Cliff and I ended up writing a short article about it. And that's why we're here to do the webinar today. So the American Alliance for Equal Rights, they challenged this private company's venture capital grant for female businesses. And so, if you can imagine, this is kind of similar to a lot of different private companies, their own diversity internal programs. If they're going to target either funds or or employment positions for specific underrepresented groups, this is something that needs to be on their radar right now. So first, let's talk about the defendant company. They're called the Fearless Fund Management, LLC. I actually have a personal connection to them. A good friend of mine from high school who lives in Atlanta. He actually does business with this venture capitalist firm. And so when we wrote that article and I put it out on like Facebook and LinkedIn, he contacted me and said, "Hey, I know those people. This program, it definitely was done with good intentions.
Yeah.
It was designed to help and target disadvantaged communities." This case is, it's kind of it's a wake up call. It's kind of, ground shaking. And so again, this program, they would provide $20,000 in grant money and a 30-minute one-on-one virtual mentorship session with a small business mentor. But it was targeted for Black female-owned businesses. Now, whether that's 51% or total Black female,
Sure.
it had to be at least 51% Black female-owned. And so first, the case was in the Northern District of Georgia, and that court initially denied an injunction that sought to enjoin their grant. But on appeal, it went up to the 11th Circuit, and in a 2-1 decision, so that's a really close decision, they found that the program substantially likely violated Section 1981 of the Civil Rights Act. So the preliminary injunction was granted, and right now it's in place. I want to talk a little bit about the Civil Rights Act of 1866, but I'm going to also defer to Cliff to expound a little bit more on that. So this section that was cited by the court, what it does, it prohibits intentional race discrimination in the making and enforcement of public and private contracts. And so that's why now they're using it to kind of target private companies here.
Yeah.
Yeah. And so the Civil Rights Act of 1866, it was initiated in the wake of the U.S. Civil War to protect the civil rights of Black people in the U.S. And so now you're seeing it being used to attack programs that are designed to promote and help disadvantaged and underrepresented groups. So it's kind of, we're living in definitely a new and different time where a lot of the statutes that were created to protect Black groups and Black people are now being used, against to say reverse discrimination. And so that's why I kind of had to we had to write that article, and we had to talk about this case, Rob.
Well, and that's what kind of caught me off guard when I heard about this before our interview was, again, the Civil Rights Act of 1964 was what we always thought was to implement, not prohibit these types of programs, right? Provide, companies with coverage for doing things to help advance and deal with those types of issues, not refrain from, not, being used to stop that. So, I think Cliff wanted to hop in and talk a little bit about that as well, to talk a little bit about the Civil Rights Act of 1966. You gave us a little bit of the history.
Well, 1866, so it goes back. We're talking civil rights, Civil War era law, and so it goes back here.
Yeah, my coffee has not kicked in, gentlemen. I apologize. 1866. It's been around for a while. So we should have, a lot of information about, subsequent decisions and how it was implemented. I'd love to hear a little bit more about the history of the act and how it's being used today.
Yeah, thanks, guys. It's pretty interesting how this happens. Obviously, we got to go back here. We always talk about this, the 60s. You've got war in the background, you got civil unrest, you got civil rights movements, you got massive changes in society, you got race relation issues. We all talk about that. And of course, I'm not talking about 1960s. I'm talking about the 1860s. You got the Civil War rolling. After the Civil War is over, you got to understand, I think to understand DEI today, we really have to understand what the law says, not what we want it to say, not what we're trying to do. And again, the good intentions, they pay the road to where, right? I mean, we all heard the saying, right? Good intentions pay the road to a pretty bad place. We have to know what the law is, because there are a lot of problems going on right now because people have great intentions, but they're not doing it in a way that's thoughtful. And if you're not doing it thoughtfully and lawfully, you could actually get in trouble when you're trying to help and actually hurt. So we got to think about that. And so we go back to the 1860s. All right, we have a civil war. Civil war is over. The North wins. All right, and when the North wins, they don't just simply say, "Hey, let's all get along." Well, they make sure they put their thumb on top of the South and say, no, 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 you're going to get in line now. And they do a lot of things. And they pass and enact all kinds of new rules that we still use today and are the basis of a lot of our civil rights that we have that are enforced. So you think about that. The 13th Amendment, we all know what that is, right? That ended slavery. That's a massive change in American history. It is a literal bellwether point where you say, okay, this is where we're going to shift as a society. But of course, it doesn't end at all. So then you have the Civil Rights Act of 1866 that's put in place. It goes through Congress. It gets to President Johnson, who took over when Abe Lincoln gets shot. And he goes, no, 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 I'm not passing this, because what's going to happen is you're going to have white people now all of a sudden take a back seat to the newly freed slaves down south. This thing is made to help that group at the expense of whites. And of course, there may be some truth to some of what the people who voted for it saying, we don't care. We don't have a lot of African Americans up in the north. You've got a lot of people down in the south, and maybe you shouldn't have started a war, and now you're going to have to deal with it. Reconstruction happens from the end of the Civil War until the mid-1870s. Federal troops are down there. They're enforcing all these rules. And the Republican government that was in charge at that time, they didn't like the South that much. So they passed a lot of laws to try to make sure that they could change the way society worked. Because remember, the North and the South had completely different ways of doing business, of running their country. So the 13th Amendment says you can't be in slavery anymore. But there was still a question of whether or not freed slaves were actually citizens. Nobody knew. So what do? Well, you pass another amendment, the 14th Amendment. Now, this guarantees that people who are now freed slaves, they were born here, they are now entitled to all the rights and benefits of a citizen. Massive change to the law. And the 14th Amendment has an equal protection clause saying people, no matter what their race is, are entitled to protection under the law. And that's still the case. And there's many discrimination suits brought under that. Now, there's the 13th Amendment, the 14th, there have the 15th Amendment. But sandwiched in the middle is this Civil Rights Act, because what was going on is a lot of people in the South were thinking, you know what we can do? We can make life really tough on these freed slaves. So basically, they got to come back into a situation where they're almost going to be slaves again. And so the Civil Rights Act goes through. Johnson denies it. The Republicans override him, and they say when they do it, no, 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 no. This doesn't apply just for the freed slaves and Black people. This applies to anyone. Doesn't matter what your race is. Now, obviously, the intent was for what? To help the freed slaves, the Blacks in the South and everywhere. But the reality is to get it through, they go ahead and say that. Reconstruction continues. The North is trying to change society down there. Eventually, over time, everybody loses interest in things and people go back to doing other things. And so what happens? Well, we start looking at different ways to do it. Supreme Court goes on its way, and they happen to hand down a decision in the 1890s called Plessy versus Ferguson. And it says basically, look, separate but equal sounds about right to us. We're going to go ahead and continue that and allow that to happen down south, and everybody turns a blind eye. The Civil Rights Act of 1866, which Ray described, kind of goes down the path of really nowhere. The 14th Amendment, which is also sort of the same thing, trying to make sure it's equal protection, becomes less worried about race than it does whether corporations are a person, than whether they're protected under the law. Whether can you tax them? Can you force a corporation to do something? Do they have certain rights? And they start battling over that for the next 100 years, almost 100 years. Nothing new is happening in civil rights. Let's fast forward a little bit, though. We get to the 50s, and we've got some people to say, you know what, this is not okay. You know, we start getting a groundswell to say, okay, we had a lot of changes, and now we fell backwards, and now we got to move forward, and how are we going to do it? We got some really good legal minds that were involved. Thurgood Marshall has a group that's coming through, and they start passing some laws, and they start looking at different ways to try to enforce equal protection, and they're trying to go against some of the separate but equal concepts. And they push a legal concept of trying to get equal rights for Black Americans, specifically in the South, but everywhere across the country. And they might have heard a case called Brown versus Board of Education, all right, in the 50s. Yep. That changes everything. Now we start to open things up. Thurgood Marshall actually goes to the Supreme Court. He gets appointed eventually. So he goes from a guy who's basically trying to get things going from the ground up, puts a strategy together, very good strategy, legal, financed, well done, gets things going. When he gets to the Supreme Court, though, very interesting change of how we have to look at the way the law is written and why it's important to know where it came from when we're doing these initiatives. Really, the first time we see the Civil Rights Act of 1866, which you can call it Civil Rights Act, CRA of 1866, or Section 1981 of that act, we really see it coming to the forefront in the 50s. When we saw that there were an interracial couple that tried to buy a house, they said, sorry, we don't sell to black people around here. That case got taken to the Supreme Court, and Supreme Court said, no, you can't do that. So all of a sudden now we start seeing a resurgence of that act to allow people to have a contract and not be discriminated against because of their race. Then we see a number of other cases coming through. The next major case that we have is actually the one we're dealing with now when we put together our DEI cases. And it kind of sat there in the background, but now it's being used. So Thurgood Marshall wrote the opinion on a case where a couple guys got fired for stealing kerosene. They sold kerosene from a rail yard. And basically 2 white guys got fired. Another black employee did not. And they said, wait a minute, you can't do this. The 14th Amendment, the Civil Rights Act, 1866, they all protect us. We got to be treated equally. And Thurgood Marshall said, look, I'm looking at this statute, and he's saying, hey, I look at this bill, and it did not say anything about blacks only. It said it applies to all employees, all people. And so I'm applying it. And in a 7-2 decision, which is a pretty wide margin, Thurgood Marshall makes this decision. Now, there are some folks out there that say, oh, look, let's use Thurgood Marshall. He's the civil rights hero we've all talked about. Let's use his words against him. So let's fast forward to where we're at now. Now we're starting to see.
Cliff, that was a private context too, wasn't it?
That was a private, it was a private case. So private employers. So what you see is not just government actions, but you're seeing private actions being taken. Okay. So we are seeing now a dramatic shift in saying it's not just the government, but we're trying to enforce contracts. We're trying to enforce, basically arm's length employment decisions on this issue. Now we get to the 60s, and obviously we've got a lot of decisions coming forward. Some very important civil rights legislation gets passed, including the Civil Rights Act of 1964. Okay, and now that's got something called Title VII. It's one of the titles within this act of 1964. And it's the one that has been amended a few times, but it basically says you can't discriminate in hiring and firing and all this other stuff within your company based on race. And some other characteristics too we know about. In fact, it almost got torpedoed because someone threw sex in there as a protected classification, thinking, well, I know these senators might vote on race, but they're not going to vote if we say we got to protect women too. I mean, they're going to be treated the same. This is the 60s, early 60s. They tried to torpedo it, but it did get in there and enshrined because they were trying to actually do it. So politics has a lot to play. So if you look at the history of what we're doing, we got a very old law that's sort of been looked at differently based on the political and judicial makeup of the country. And now we're where we're at right now, which is we have a number of very important laws that are floating around about protections of rights. And the question is, how far can you go to protect rights without running too far and violating these very established issues of discrimination protection? So when you look at the case in the private sector now, that Ray was talking about the hedge fund and what you're doing, what they're saying is, are you essentially keeping people out of your grant programs, your investment programs, because of their race? Is excluding one group hurting another group? Now, not specifically on point, but like, we were talking about here just a couple months ago, we have a decision that came down in Harvard and North Carolina by the Supreme Court that looked at a different statute, different section of the statutes, Title VI, and it said that the programs that those two colleges had where they use race as a factor was unlawful. There was a case before then that said you actually could do it for a time. But they said basically that time is up now, and that those programs, by just giving you certain points or using as one of many points, was not okay. They said you might be able to apply and say how race has affected you. You could say how you've overcome it in your essays. And they're saying don't use that as a template. Don't try to get around it. But you could do something like that. So they put an end to this concept of you can use race generally, because what they said is Asians and some whites, but mostly in this, some of the motions, it was Asian Americans who were saying, hey, I have to do more than another group based on race. That's unlawful under your statutes. Now, at the time that comes down, everybody starts saying, whoa, what's going to happen in the private sector? The Equal Employment Opportunity Commission comes out and says, hey, everybody doing these DEI programs, everybody interested in affirmative action, listen, just want to let you know, this case has nothing to do with us. That's a completely different statute that has to do with federal funds going to institutions like this. We are going to continue to have and encourage DEI, diversity, and all these other programs that are helping people out. However, they also, at the same time, also put out a note saying, hey, you better be careful. You better take some warning on what you're doing and how you're writing these things up, because if you do run afoul of these, you're going to be in trouble. So the EEOC itself is saying, we want you to do it, but you have to be careful how you do it so that you don't exclude people. Now, I want to talk a little bit about politics real quick, and Ray, you can jump in, but what we have is a legal issue. We've got ethical issues. All right. Now we've got ethical issues, like, and Rob and I have talked about this before. They're not always on the same grounds. Ethics change, the law changes, the interpretations change. I mean, listen, 12, 15 years ago, there wasn't a country in the world that recognized gay marriage. Now it's an enshrined protection in Michigan's statutes, right? It's unlawful. It's protected by the Supreme Court of the United States. The current Supreme Court has also said that sex includes these characteristics that were never involved in a change by the legislature. They just interpreted it differently than they did in the past. Okay, so you have these changes in interpretations. Now we're having to deal with, now we're at another bellwether moment. We're seeing the tide change. We're seeing these cases come. So we have to make sure we sand the edges off our programs to make sure they can play. In Florida, there's a law, and it is an extremely aggressive law, but it's basically a no woke laws, what people have called it before. Basically, you cannot teach and require employees in certain businesses to be told mandatorily about certain concepts that DEI programs talk about. And that would be, there's institutional racism, that racism has a part in why there's problems in the workplace. Some of the seminal issues you see in DEI discussions, you have to be very careful. At the same time you're getting that advice, you've got federal contractors getting executive orders saying you better go out there and you better make sure you meet certain quotas and you better meet certain thresholds on how you do your business. And then we have affirmative action plans that are part of that issue. And it's very, very complicated on how you do it right, because you can't have a quota system for hiring. You can't have certain metrics, but you do have to do lots of paperwork to make it right. There's voluntary, there's involuntary, but they all are supposed to be short-term with metrics involved.
So with that with that in mind, Cliff, what are we seeing actually as far as the cases in employment and DEI? How do we distill this down to some practical? Here's the historic problems that we're facing. These are the things you need to be looking out for in the time we have left.
Well, let's talk about this real quick. What we're seeing in light of the decisions of the Supreme Court and now the active, aggressive push of some of these well-funded groups and law firms is we've actually seen multiple law firms, international law firms, sued because they were putting together programs as part of their DEI mechanism to have minorities be able to get a scholarship essentially to work for them. They would work, they would get so much money,
or clerkships. Suing them.
Yeah, and that's a big deal. And Ray, maybe you can talk a little bit about that and how that's really changed the landscape.
Yeah, sure. A lot of especially in the law firm sphere, there are different like minority clerkship programs that law firms participate in, and the future for some of those programs doesn't look great under this current Supreme Court and this current this current view of how they're interpreting the Civil Rights Act. But one of the things that I think maybe employers need to adapt to is to try to target certain groups by like region or area, to maybe try to target, different, programs or summer clerkship positions by, having a, like a Metro Detroit focus, or, like an urban focus, or, having it where it's race is not the
Explicit.
sole distinguishing factor, but you're still targeting people who are, disadvantaged, based on, either locale or some other factor, right? And so you can still have those good intentions, but without using race as the deciding indicator. And another way is, just I think more straightforward and easier is, you should be targeting more diverse, law schools or colleges. Why aren't we doing more, was a resume pools from HBCUs, or do more advertising for positions at schools that do have more of a diversity component. So if your pool of people that you're looking at is more diverse, you're going to get more diverse results. And so there are ways to have those good intentions and to increase the diversity within your firm and within your company without violating the law as well, by specifically targeting race. I don't know. What are your thoughts, Cliff?
Well, and I do want to hop in just for a quick second, because it's an interesting point you make, because we just talked about this in, I think, 2 or 3 sessions ago when we were talking about AI and using AI to screen resumes and things like that. And what we found is that certain AI tools, just by virtue of targeting, whether it's certain schools or certain zip codes or certain areas, were creating some implicit biases where they would exclude, certain protected classes just because of the zone. So it's really interesting to me that one of the solutions that we have, and I think it's a great solution, is look at it from the inverse, right? Instead of having those targeted zones be a precluding factor, used as an inclusive factor to try to get around the explicit, hey, we're trying to hire this particular race, or this particular socioeconomic. So again, I apologize for cutting in, but I thought it was a very interesting interplay on one of our prior coffee break sessions.
I want to really quickly, because I know we're running out of time, address 3 points. I think Ray made some great points, and Rob, you did too. Here's what is going on. You have to understand where the EEOC is coming from. The EEOC is a federal agency in charge of monitoring discrimination, but the courts make decisions, right? So while they are charged with enforcing and interpreting the law, at the end of the day, the courts make the decisions on what the law is. So they're a federal agency. Now, the EEOC statement, and I saw some notes saying people like to have some links to it, and that's absolutely a great thing to do, great place to start. I mean, they're encouraging people to go out and continue to have DEI programs. But what I'm encouraging you to do is to do what they also said back in 2006. I mean, this isn't new, where they said, look, be careful in how you draft it, review it, and make sure you know what the results are. If your program is what these law firms were having that had lawsuits against them, the group that brought the lawsuit backed off when they said, you know what, we're not going to exclude certain people from being in this based on race. We're just going to have a diversity focus. We want people that are committed to a diverse, equal workplace. Mm-hmm. What the EEOC has done before is say, go out and train people on discrimination in the workplace. Train them on what it means to be discriminatory, what your policies are. Have robust, strong policies. Educate people on there. Those are valuable tools to make sure you do it, because when those law firms were sued and they backed off and said, okay, you can have that internship with the focus on this area, but make it open to people who doesn't matter what your race is, they all of a sudden dropped out of it. There is a new case, and it's the second point, a new case that's going in front of the Supreme Court. They just took it up. We don't know the decision yet. And it may redefine what an quote unquote adverse action is. So what is it that actually makes a person discriminated against, right? What is it about your DEI program that's wrong? So the first thing you do is you go out and you can safely go out and start recruiting in better places, right? In better places, I mean places that go out and get a cross-section of people that's diverse in its opportunities, right? That's a great way to do it. Second, you train people on what diversity is as far as a legal matter and what we can and can't do in our policies. But what we have to be aware of is there are lawsuits. The city of Seattle, for instance, I was looking before we got here, has just been sued because a plaintiff has said that the diversity initiatives, including mandatory diversity trainings involving critical race theory and encouraging participation in race-based affinity groups, caucuses, and employee resource groups for discrimination, they tried to get that dismissed. The city of Seattle did, and the court denied the motion. And that's right now. That just happened in August. We're going to continue to watch that. The question is going to be affinity groups. A lot of employers want to have affinity groups, which means, hey, we want to have a group for African Americans, a group for employees that identify as LGBT, people from different genders, things like that, which is a great idea. It's a great opportunity. The question is going to be, if you exclude in an employment setting by the employer's decision access only to those people who are of that affinity, is that discriminatory? So the purpose could be right if you open it up to everybody. But if you exclude employees, now all of a sudden you've taken a great idea and you've made it exclusive.
Yeah.
So what we don't want is what a lot of employers and places are doing now, which is they're just basically watering down their programs. They're like, you know what? We're getting rid of the concept of DEI. We're going to call it something else. We're not going to have a program. No, that's not what you want to do. Your DEI program has to be tailored, watched, monitored, and comply with restricted. We want to get away from restrictions. We want to get rid of hiring. If you hire based on race as a factor, that's a problem. If you have an incentive program, if you start making people go to things that teach them that, look, you're not going to get a job, you're not going to get a promotion, you're not going to get this because we're only looking at this one factor, or it's a factor, you've got problems. So we have to be careful in how we draft those programs. And I don't think it's one where I can say, hey, everybody, here's a really good program that works for everybody. No, it has to work for you because your operation's different, right? We have to make sure it complies because you may be under a court order. You may have a federal contract. You may have a state contract that requires certain things. We have to make sure you individually make it appropriate under the law, and understanding there are probably 50 cases ongoing right now, not only about the DEI programs, but saying if you mandatorily make me go to a program that teaches me things that make me feel like I'm not going to get ahead in my workplace, that's discriminatory. So that's the next level of attack that we're going to see.
Yeah. Right. Unfortunately, sometimes it's not exactly, what you say, it's how you say it, right? Mm-hmm. It's how that issue is framed. And again, this is our Wednesday, second Wednesday coffee break session. This is not a topic we can cover in all different respects in 30 minutes. One of the questions that we got is, what kind of guidance can be, provided to, employers to deal with some of the, the obvious conflicts between legal and ethical issues. And I think what I heard you say is that it really is a case-by-case basis, right? It requires an analysis of your program to figure out, if there is a risk and if there's not a risk. So,
hey, Rob, before we go, hey, can I add one? I just want to get this one out. I want to make sure. I don't want to scare everybody, but I do want to say reality.
I'm going to.
Yeah, I mean, it kind of is a little bit scary because it's a fact-based situation. There was a case down in North Carolina back in 2019, so it's not recent, in 2019, where a person said, listen, I think I was fired at least in part because of my race and my sex. And they said, look, you have this program, this DEI program that taught what it taught, right? How that DEI program was done. So it had an existence there. And then I was fired. And that's one fact that I have. And a jury awarded $10 million in that case. Now it was reduced to $300,000 later. Now that DEI program is different than everybody's DEI programs. And the fact scenario for why that person got fired was different. But there are real world issues that we have to look at to make sure, because it's not in a vacuum. None of these facts are in a vacuum. They have to be looked at in totality of your operations, your organizations, the law, the politics, your state, your local government.
Right. Your own situation and practices. Exactly. Yeah.
So I anticipate that we're going to have a lot more information coming up, both on the Foster Swift website as well as subsequent presentations. I know this was one of our more timely topics. Certainly a lot of interest. Just look at the questions, both public and private, that I've gotten. There's a lot of uncertainty as to how to craft these positive programs to make sure that they survive. Again, at least what we see right now on the scrutiny. So I do want to thank you both for taking your time out of your day to talk to us about this. Again, when I first heard about this topic, this conversation wasn't the way that I thought it was going to go, right? Unfortunately, it seems that we're going a little bit backwards, at least based on this one decision that's there. But I did also hear the good news that there do seem to be some ways that we may be able to navigate this decision and keep going with those programs. So, but again, definitely going to be a case by case basis. So again, I want to thank you both for taking your time to speak with us today. I want to invite everyone to join us one more time this year on December 13th for our second Wednesday coffee break session. It will be hosted by Paul Millenbach and featuring Jennifer Monaster, where they're going to be talking about parenting time issues during the holidays. Obviously, a very timely thing to do right around December, and I do know that that is a topic that they've written actually rather recently on. So, but again, thank you everyone for joining us today. Please be on the lookout for more information coming from Foster Swift on this topic, as well as posted on our website, where I believe that you can sign up for some newsletters and articles and distribution services as they're coming out. Because again, I'm anticipating a lot more information coming on this topic as it works its way through court. So again, thank you everyone for joining us today. Thank you again, Cliff and Ray, for taking time out of your day to talk to us about this topic. And we hope that you all have a fantastic week and look forward to seeing you at our next Wednesday session, coffee session. Thank you so much.
Yep. Thank you, guys.
Thanks.